Hello! Today we'll give you your essential guide to creating a last will and testament. When it comes to safeguarding your family's future and your hard-earned assets, a will stands as your personal sentinel. Creating a legally binding will, regardless of wealth, ensures that your assets and loved ones are protected and reduces the likelihood of disputes after your death. There are different types of wills available to suit individual needs and circumstances, and understanding each type's nuances is crucial in estate planning. Regularly updating your will in response to life changes is essential for maintaining its accuracy and effectiveness, ensuring that it always aligns with your current wishes. Now, let's talk about demystifying wills and what you need to know. When it comes to safeguarding your family's future and your hard-earned assets, a will stands as your personal sentinel, ensuring your final wishes are realized and disputes are laid to rest. This legally prepared document is not just about who gets the china cabinet. It's a blueprint for asset distribution and guardianship arrangements, critical for anyone with something to their name or someone to protect. As we navigate life's unpredictable waves, a will serves as a compass, providing clear instructions for how property should be distributed upon our departure and playing a pivotal role in preventing future conflicts among those we leave behind. Next, let's shatter a common illusion. Wills are not the exclusive domain of the wealthy. Whether you own a sprawling estate or a modest bank and brokerage account and some personal property, having a will is a testament to taking responsibility for your assets and loved ones. It's about preparation, not wealth. So, let's demystify the legalities and processes that often seem daunting at first glance when it comes to creating an estate plan. A will is more than a piece of paper. It's a cornerstone of estate planning, carrying weight only if it's legally binding. To achieve this, the person creating the will, known as the testator, must sign it in the presence of witnesses and have it notarized. Yet, not all wills are written in stone. Some, like non-cubitive wills, those spoken rather than written, may not hold up in all states due to varying legal standards. But even a legally binding will has its boundaries. Certain states' laws, such as those protecting spousal rights and ensuring children's inheritances, can place restrictions on how freely a testator can give away their property. It's a balancing act between personal wishes and legal constraints, and navigating this requires a careful understanding of state law and potentially the guidance of legal counsel. Seeking legal or tax advice can be beneficial in these situations. The probate process is a legal procedure that can seem as mystifying as an ancient rite. Yet it's simply the method by which your estate is settled under the supervision of a probate court after you pass away. It's the crucial, albeit sometimes lengthy, step where your will's directives are put into motion and your assets are distributed to your beneficiaries. However, not all assets are bound by probate. Those owned jointly, for instance, bypass this process, transferring directly to the surviving spouse or owner without the need for court intervention. Understanding the probate process is vital, as it affects how and when your beneficiaries receive their inheritance. It's a good rule of thumb to consider how your assets are titled, and the implications for your estate plan. With this knowledge, you can better prepare for the journey your assets take after you've set sail for the great unknown. When you write a will, do you know the type that's right for you? The world of wills is not one size fits all. There's a type suited for every shade of complexity and personal circumstance. Whether you're a young couple starting out or a seasoned individual with a diverse portfolio, choosing the right will can ensure that your estate plan reflects your unique situation and wishes. Some common types of wills include simple wills, living wills, online wills. But how do you decide which will is the right fit for you? It's like selecting the right tool for a job. You must consider the scope of your estate and your goals for the future. Let's navigate the various types and understand their nuances, so you can make an informed decision that ensures your legacy is preserved according to your exact specifications. A simple will is the bread and butter of estate planning documents. Perfect for those with uncomplicated estates who wish to outline their basic desires, like naming an executor or appointing a guardian for their children. It's straightforward and to the point, but don't be fooled by its simplicity. It still requires the formalities of being signed in the presence of witnesses to be considered valid. Think of a simple will as the first will you might create, a starting point that can evolve as your life and net worth grow. It's a legal document that says, here's what I have, here's who I love, and here's how I want my assets to pass directly to them. A last will is the foundation of a good estate plan, and most states have clear guidelines to ensure that these wishes are honored when you're no longer here to voice them yourself. For those looking to add layers of protection and structure to their estate plans, a last will and testament with a testamentary trust might be the answer. This legal document comes into play after you've bid adieu to this world, establishing a living trust that meticulously manages and distributes your assets according to your final wishes. It's an elegant solution for ensuring that your legacy is handled with care, providing for your loved ones over the long term. The real magic of a testamentary trust will is in its ability to set conditions on inheritances, offering a level of control that extends beyond the grave. Whether you're safeguarding a child's financial future or orchestrating a philanthropic gesture, this type of will ensures that your assets are not just distributed, but stewarded according to your precise intentions. In the digital age, even wills have found a home online. The creation of online wills through online services offers what is promoted as a cost-effective option, especially for those with less complex estates. But as with anything in the virtual world, it's essential to do your homework and ensure the service provider's legality and trustworthiness to avoid future complications. These digital documents promise your estate planning done with a click, yet they must still meet all the legal requirements of your jurisdiction to be valid. It's like sending an email with the most crucial message of your life. You want to make sure it gets to the right inboxes and isn't lost in cyberspace. As with any legal will, an online will should be crafted with clarity and foresight, so when it's time for your assets to make their journey to your designated beneficiaries, they'll have a map that leads exactly where you want. Unfortunately, they often don't cover items like an advance healthcare directive and can have tax consequences if not properly prepared. As online wills have become more commonplace, there are more and more wills entering probate because something was missed or doesn't conform to the particular estate's guidelines. Let's go over the key components of a well-structured will. A well-structured will is like a well-orchestrated symphony. Every element plays a critical role in ensuring your final act is a masterpiece. Key components such as executor selection, guardianship considerations, and explicit asset distribution instructions are the heart, soul, and rhythm of your entire estate plan. Embarking on this journey requires attention to detail and a deep understanding of the roles each part plays. So, let's look at these components and uncover how to harmonize them to reflect the legacy you wish to leave. The executor of your will is the conductor of your funeral arrangements and posthumous wishes, tasked with the solemn duty of bringing your final instructions to life. This role is not for the faint of heart. It calls for someone who is trustworthy, organized, able to navigate family dynamics, and knowledgeable about the complexities of estate administration. Choosing the right executor is a decision that can echo through generations. It's about entrusting someone with the essence of your life's work and knowing that they will honor your wishes with integrity and respect. As life changes, so too might your choice of executor, making it essential to keep your will updated to reflect the most capable hands to carry your legacy forward. When it comes to the well-being of minor children, naming a guardian in your will is a declaration of love and responsibility. This person will shape your children's futures in your absence, making it a decision of profound significance. Your will should outline not just who will care for them, but how they will be cared for, reflecting your values and hopes for their upbringing. In this delicate matter, you're not just selecting a guardian, you're sculpting a future for your children under the guidance of someone you trust. It's about considering all possible scenarios, including the potential inability of your chosen guardian to serve, and having contingency plans in place to ensure your children's uninterrupted welfare. The art of asset distribution in a will is a complex tapestry, interwoven with emotional and legal threads. It's where your tangible life's work meets the intangible affections of those you care about. And it's crucial to address potential disputes and legal considerations to ensure a smooth transition of your estate. Whether you're leaving a monetary legacy to a charity or ensuring your digital life is managed according to your wishes, every asset, including personal property, should be accounted for in your will. From the disposition of real property to the management of retirement accounts and bank accounts, clear instructions will prevent confusion and uphold your wishes. Special provisions, like no contest clauses, can also be employed to deter challenges and maintain harmony and mutual will among beneficiaries. Wills and trusts often travel in tandem on the estate planning journey, each with its unique strengths and roles to play. While wills come into effect after you've left the stage, trusts are like the understudies that can take over at a moment's notice. They are operational upon creation and funding. Trusts sidestep the probate process, providing a potentially smoother transition of assets and preserving privacy. Understanding the interplay between these two instruments is akin to mapping out a treasure hunt. You need to know where each clue leads and how it connects to the bigger picture. Trusts can stand as the primary means of asset distribution, but they're often paired with a will to cover any overlooked treasures, ensuring nothing is left unaccounted for. The choice between a revocable and an irrevocable trust is like deciding between a flexible line of credit and a locked-in investment. Each has its benefits and trade-offs. Revocable trusts are the chameleons of the estate planning world, adaptable and changeable, allowing you to maintain control over your assets while setting the stage for their future distribution. On the flip side, irrevocable trusts are the fortresses, offering robust protection from creditors and potential estate tax advantages, at the cost of surrendering control of other assets. The decision hinges on your personal priorities, whether you value flexibility or protection, and how you want your assets, including investment accounts, to be managed now and in the afterlife. Pour-over wills are the safety nets of estate planning, catching any assets that might have slipped through the cracks and funneling them into a trust upon your death. They work in concert with trusts, ensuring that anything not explicitly placed in the trust during your lifetime finds its way there eventually. This mechanism is crucial for full coverage, preventing assets from straying into unintended hands and upholding the comprehensive plan you've crafted. It's your way of saying, just in case I miss something, here's where I want it to go, providing an extra layer of assurance that every asset is part of your legacy. Wills are living documents, evolving as your life does. A will, as well as regular reviews and updates, are not just about crossing T's and dotting I's. They ensure that your will remains a true reflection of your wishes and circumstances as they stand today. Whether it's a new addition to the family or a significant change in assets, updating your will is how you maintain its relevance and effectiveness. Let's explore the when and how of keeping your will current, ensuring that it always serves as an accurate blueprint of your intentions. Life is a tapestry of significant moments, each capable of altering the course of our legacy. Major life events such as marriage or the arrival of a new family member are not just cause for celebration, but are also pivotal points at which to revisit your will. A major life event can shift the dynamics of your relationships and assets, necessitating an update to your estate plan to ensure it mirrors your current life stage. Divorce is another such life-altering event, and it's critical to update your will accordingly to reflect your new circumstances. In most states, the law may automatically disinherit an ex-spouse from an existing will upon divorce, but it's prudent to revise your will to clearly define your new beneficiaries and prevent any ambiguity. Similarly, the passing of a named executor or named beneficiary is a call to action, a reminder to adjust your will so that your estate is always in capable hands. Even the best-laid plans need tweaking, and your will is no exception. For minor adjustments, a codicil may suffice. A legally recognized addendum that must adhere to the same formalities as the original will. However, be wary of potential ambiguities that could arise between the codicil and the will, as these could sow seeds of confusion or legal challenges. In some cases, particularly if your original will is lost or if significant changes are required, it may be wiser to draft an entirely new will. This fresh document should explicitly state that it revokes all prior wills and codicils, ensuring there is no conflict between past and present versions. Whether you choose to amend with a codicil or create a new will in a separate document, it's essential to have these changes legally validated to preserve their effectiveness and your peace of mind. From dispelling myths to detailing the intricacies of asset distribution, we've journeyed through the essential aspects of creating and maintaining a last will and testament. Remember, a will is not a static document, but a reflection of your life's narrative. One that requires regular updates to echo your evolving story. With this guide, you're now equipped to navigate the process with confidence, knowing that your final wishes will be honored and your legacy preserved. Take the next step to protect your family, safeguard your assets, protect your loved ones, and ensure that your story endures. Contact TrustWorks today, and let us give you a free in-office estate planning consultation with your local TrustWorks attorney. Call today.